topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning, Philadelphia. Welcome to another Ask the Expert show. This is our 10th year of airing Ask the Experts. We used to be on just radio. Now we are streaming live on TV. We do our podcast as well as our radio. And none of this could be done unless we had our special sponsor, Michael Cardamone Law Offices. Michael's with us the last Tuesday of each month at around 10:25, and Michael talks about workers' comp law. This is the greatest show to listen to or to watch, especially if you've never been injured on the job, but you have a job that you could be injured on. So let me welcome you to, I have to say it this way, Michael's been with us for a long time. He is, without a doubt, the top workers' comp lawyer in the state of Pennsylvania. Welcome, Michael Cardamone.
Good morning, Steve. How are you?
We're doing great. That's amazing. After about 3 years, we have just set up in the last 3 weeks a new kind of format with your show. And it's basically because we get so many emails and phone calls about your show. We have decided, instead of us asking you questions, that we just give the questions over to the viewers and let you answer them that way. And I got to tell you, we got about 30 people who wrote us or called us with great questions, which you will be answering today. But Michael, before we go any further, I've got to do this because we're getting so many new people every day. Please tell everybody about your firm and about your background.
Sure. So I graduated law school from Villanova in 1999, and I've been practicing law ever since. I opened up the Cardamone Law Firm at the end of 2013, and our focus was 100% on workers' compensation for injured workers, not for the insurance companies or not for both, but just for injured workers. So we're a small boutique firm. We have offices in eastern and central Pennsylvania. Our primary office is in Lansdale. We have a Center City, Philadelphia office as well. And Attorney Silver and I, we work on every case together. So I've been telling our clients, you're lucky because you have about 64 years worth of combined experience in workers' comp on your file and so in your case. So and we're kind of unique. There's not many firms in Pennsylvania that only do workers' comp. So that's sort of how we stand out. A lot of firms will do workers' comp and Social Security disability and some personal injury maybe, but we're really focused and only in workers' comp. So it gives our clients an edge. We like to tell people.
Michael, I like to tell people, because I think it's so important, that when you hire a firm, that it's better, and this is just my personal feeling, that it's better to retain a firm who solely works in a certain area of law. In your case, it would be workers' comp law. Because if you're going to a doctor and you needed, say, an orthopedic doctor, you would not want that doctor to also show that he does pediatrics, he does chiropractic care, and a whole list of others. And that's what I love about your firm, that you concentrate on workers' comp and workers' comp only.
Yeah, I mean, another analogy could be, two sports teams in the NBA or NFL. These games are won in the trenches, and the finer details. And so, by focusing just on workers' comp, we're able to give our clients that little extra edge. That maybe we're a little more familiar with the judges, and they see our face a lot more often, or we know which petition to file, or we know how to really cement our argument in a nice written brief at the end of the case. Whereas maybe some of the other firms who are doing a little bit of this, a little bit of that, they might not have such refined processes. So, I think it really does give us an edge because those little details get add up in a given case.
Well, let's get started on our brand new format. First of all, thank everybody for the questions that they wrote in. We're going to start off with John in Philadelphia. He said he's had low back pain for years since high school. He was, I guess, hurt in a wrestling injury, but now his work has made it worse. Can he still pursue this as a workers' comp case?
Yes. And there's a lot of misunderstanding about this topic, Steve. The answer, John, is basically yes. If you have a doctor who can state within a reasonable degree of medical certainty that you have aggravated a prior condition or a prior injury, that is considered a viable workers' comp case. And a lot of people don't pursue comp because they say to themselves, oh, I had an injury like John did, years ago, wrestling or in football or just lifting something at home, and they're going to find out about it. And yeah, they will through testimony, and you'll be honest about it and tell them your prior history. But if you've made it worse at work, that is a work injury. And a lot of people don't understand that. We have a lot of repeat clients because, to their credit, someone after a back injury may end up going back to work. They start feeling better. They get a light duty job, something a little bit lighter, and then they hurt themselves again, and they're back in our office. So, but yeah, the bottom line is an aggravation of a prior condition is a work injury. And that's a lot of reason why the adjusters aren't always educated on this, or if they are, they like to ignore it. But a lot of claims are denied because of that specific reason. They'll say it's a pre-existing condition. That may be true, but if it's made worse, either from looking at an MRI study or clinically, then it's a work injury. So he's going to have a strong case there.
Michael, is there a statute of limitations on an injury?
There is. In Pennsylvania, Steve, it's 3 years from the date of injury, or 3 years from the date you first believe your condition may be work-related. So if you're not sure, but you kind of have a hunch, the clock will start ticking. So 3 years is a long time. In personal injury cases, it's 2 years, at least in Pennsylvania. In workers' comp, it's 3 years. However, we don't ever recommend to our clients that they wait that long. I mean, people's memories fade, of course. Naturally, a judge or the other attorney might be a little cynical about why they waited, and maybe they weren't confident in their claim. They start maybe drawing some inferences. So I always tell people, if you're sure you got hurt at work, let's pursue it. There's no real good reason to wait.
I guess this is from Jackie in Willow Grove. He or she wanted to know, what if the doctor doesn't agree with them or believe them? Can they see another doctor?
Yes. Normally, most employers will have a list of panel doctors, and that's one of the downsides of workers' comp in Pennsylvania. There's a lot of upside compared to other states, but the employers and their carriers have control in the first 90 days. So you are allowed to see another doctor, get a second opinion, but those doctors are usually going to be cynical or maybe not express their opinion about causation, meaning work relatedness. And they tend to rush people back to work and try to characterize everything as a strain or a contusion. So, but once you're out of that 90-day period and you're able to see somebody more objective, the doctor will generally respect what the injured worker says. And if they say it happened at work and they have no evidence refuting that, then most of the doctors will agree that it was a work injury based on the history and assuming it's true. But the bottom line is, yeah, you can see another doctor. And once you're over that 90-day hurdle, there's really no limit. I don't recommend it, but you can bounce around to 5 or 6 different doctors. The other side might think it's doctor shopping and may look down upon it and frown upon it. But, so after 1 or 2 doctors, generally you kind of hit a dead end. But yeah, they can get a second opinion for sure.
Okay, let's skip over to Sharon in Fort Washington. She wants to know, can I appeal a decision from a judge?
Yes, it is very difficult to get these decisions overturned. But yeah, you have a right to appeal. When you have a judge's decision, you can appeal it to what's called the Workers' Comp Appeal Board. And there'll be an oral argument and a written argument. You can waive the oral argument, but if you want to make your case in front of the commission, then you can do that. If you want to appeal the Workers' Comp decision, the Workers' Comp Appeal Board decision, you can then go to the Commonwealth Court of Pennsylvania, and from there, the last option is the Pennsylvania Supreme Court if they find that it's an important enough issue to address. So they have some choice. But yeah, a lot of people want to appeal their decision. Unfortunately, the odds of getting them overturned are very slim. More often, we'll see what's called a remand. That means it's sent back from the Workers' Comp Appeal Board to the Workers' Comp judge to discuss findings that maybe they skipped or the appeal board thinks is important. But a lot of times, you see the judges kind of rubber stamp their original decision. So if it's a close call case, you really want to try to settle these if they're being reasonable on the other side, because once you get that decision, you're probably say about 95 to 99% of the time you're stuck with it.
We're talking to attorney Michael Cardamone. He is a workers' comp attorney, and I got to tell you, if you have a job where you could even possibly get hurt, this is the greatest show to listen to or to watch, because you can learn so much from this show. Let's go to William and Ardmore. Will a jury hear my case, or will it be a judge?
William, the answer is it'll be a judge, and you'll have the same judge throughout your petition. And then once that petition is decided, you may end up back in court on another petition. Let's say your original petition is a claim petition seeking benefits, and we win that case. 6 months later, the IME doctor, the insurance company doctor, might claim you're recovered, and we might disagree, and they file a petition to terminate. That petition could be assigned to another judge. But there's no jury in workers' comp in Pennsylvania. It's just one judge, and that's it.
Well, the caseload must be pretty heavy with one judge handling a case.
Well, yeah, I mean, luckily we have them scattered throughout the state in each county. So in one particular location, there might be 2 to 4 judges. In Philadelphia, of course, or Pittsburgh, you're going to have more. And the judge matters. Some of them are a little bit more liberal and leaning injured worker in a close call. Some of the other judges are a little bit more, they have a reputation for siding with the insurance company and the employer if it's a close call type of thing. So when you get the draw, it's called an assignment notice. It comes out right after you file a petition. You look on it and it'll tell you the judge, and that's a real factor in these cases.
I'm sure. This is from let's see. Oh, Gary in King of Prussia. What if I have a short-term disability benefit? Isn't that good? Isn't that as good as workers' comp?
That's such a common question. So the short answer is no. It's far inferior. Short-term disability, the system is not as fair as workers' comp. When you're in workers' comp court, you really get a fair shake. It can take a long time to get the due process. It can take a year on a given petition, but we have a really good system with a lot of rules. The short-term disability and long-term disability, the decisions I find are a lot more arbitrary, and it's a lesser amount of money in most cases than workers' comp on top of it. And then finally, you don't have the option of settling for a lump sum. In Pennsylvania, a lot of our cases will settle for compromise and release agreement. It's a lump sum. to end the case forever in exchange for that amount of money that's negotiated. You're not going to have that in short-term disability. The benefits will just run out. And it is a little bit less money as well, too, in most cases. So workers' comp, you can have both going at once. And then if you win the workers' comp, there's an offset to the extent the employer funded the premiums for the short-term disability. But usually there's a balance there between both numbers.
I got to tell you, it seems I was really surprised about all the women who've written in. Not that workers' comp is mostly for men, but I was kind of surprised. Does that surprise you, Michael?
No, the biggest reason why I'm not surprised is a big sector of our economy right now is in healthcare. And obviously you're going to have more female nurses than men, although starting to get a little bit, starting to even out over time a little bit. But a lot of women are drawn into the healthcare field, and we get a lot of them. Probably every week, maybe every 2 weeks, we get either a nurse or a CNA who's maneuvering a patient or helping them to bathe or shower or helping them in or out of a wheelchair, and they hurt their back or their shoulder or their neck. And so we have a lot of women clients, and especially from that particular field.
Michael, do you ever get a client that works in the food industry, say at a restaurant, who gets food poisoning?
I haven't seen that, although that would be a viable claim if you can establish the source of the illness. More often though, Steve, we see maybe a waiter or a waitress hurting their shoulder or back from lifting a heavy tray. Or I've had probably 10 cases in the last couple decades where we've had chefs cutting stuff and they end up cutting a finger, sometimes even part of the finger completely off, and it becomes an amputation case. So that's probably more common than the foodborne illness type of thing.
Michael, we got a lot of emails from people with the same concerns. And here's one, Bruce in Philadelphia. How can I survive without any pay from work or workers' compensation? We had about 5 or 6 of those.
It's really a stressful conversation to have with injured workers because I've always said, like, once you're on workers' comp, the fact that our legal process takes a long time benefits the injured worker because it takes the insurance carrier a long time to get you off of the benefits. Conversely, when you're seeking to get the benefits in the first place, the fact that you can be tied up in court if it's fought the whole way can take a year. And so that's a big issue. We have to go through, without prying too much, do you have savings, and do you have some people can apply for unemployment comp. Workers' comp will get a credit for that, but it's money now versus money later. If they're able to work in some limited capacity but unable to do their pre-injury job, they could get unemployment potentially. The short-term disability is an option if they have a plan. So, but there's only so many options. And so it's really a hardship for most people to get through these months and months in court waiting for that final outcome.
Got another concern that a lot of people had. This is from Cindy in Phoenixville, about who chooses the doctor. Who picks the doctor that they use?
Normally it's the adjuster. So you call it a claims rep or an adjuster, but they're the ones kind of steering the ship for the insurance carrier. And of course, they call it an independent medical exam, but we call it on the claimant side of things a defense medical, because they're getting you examined by a doctor that they're familiar with and who may have a reputation for finding a recovery, or disagreeing with the treating doctor's restrictions. So we know which doctors, when we see the independent medical exam notice, 80% of the time, we know what their opinion is ahead of time. And that's sad. It should be objective. They should tell it like it is, be honest. But, when you're dealing with opinions, it's easy for somebody with a skewed lens to say, well, I'm going to blame this on degeneration. And yeah, they have back pain, but I'm not going to call it a work injury anymore. I think they just sprained their back and now they have degenerative arthritis causing their problem. So you see this in a lot of cases where their doctors will claim a recovery and the treating doctor will say no, and then you're in court, fighting over it.
This is from Christine in Chester. Can an injured worker who is on or seeking workers' compensation benefits still apply for Social Security disability?
Yes, and they're not mutually exclusive ideas. So if you're waiting for your workers' comp case to pay out and you're totally disabled, basically the standard there is, are you able to engage in substantial gainful employment? In workers' comp, the issue is really, are you able to do your pre-injury job, or some cases, a light-duty job that may have been offered after an injury? So in Social Security disability, you're claiming you're completely disabled. You can't even do sedentary work. And in that realm, every condition you have is relevant, whether it's a work injury or just, something you're dealing with on the side, a heart issue or anxiety or a knee problem from a football injury. All those things combined, if you're unable to work, you'll be successful. Whereas in workers' comp, the focus is more narrow. It's just, what are the work injuries? And are you able to do your pre-injury job, essentially?
There's I guess this is Hank in Doylestown. Love your show. I've learned so much, so I try never to miss one of your shows. How long is the average injured worker on workers' compensation for?
That's a tough one because there's such a wide range. I mean, somebody could be out for a month. They sprain their back and they recovered quickly. In other cases, people on workers' comp, theoretically, you can be on forever, although that's rare. Because once you're on workers' comp, after 2 years, they can do an impairment rating, and most people fall under this 35% threshold, which then converts you to partial disability, which then gives you a 9.5-year cap on your wage loss benefit. So when you factor in all the cases, I'd probably say the average is 6 to 9 months, because most people luckily don't have catastrophic injury. They have something that knocks them out off kilter for months, and they fight their way back and they treat and they get back to work. So, but there are cases on the other end where they're on it for decades.
This is from Keith in Philadelphia. If I go on vacation or to a sporting event, or if I travel and the workers' comp carrier finds out, will that be held against me?
They'll try to use it against you, but you have to put everything in context. So let's say your pre-injury job is very physical. You're working on an assembly line at Amazon and you're lifting box after box after box all day long. You hurt your back, okay? And you're pursuing workers' comp because they don't have any light duty work for you. There's nothing that says you can't still live your life and go out to eat or go to a Philadelphia Sixers game or the Eagles game. You're sitting, you're not doing anything really physical. So it's not inconsistent with what you're alleging. In most cases, you're not alleging that you're a paraplegic with your legs up all day 24/7 and that you can't function at all. Then there would be a discrepancy if that were the case. But in most situations, when people are the insurance company spying on them, we find out that there's really not an inconsistency between what they're alleging in court and what their job required versus what they're seen doing on video. I get a lot of surveillance, people carrying milk from Wawa. And I'm like, what's your point? It weighs 5 pounds. They had to lift 100 pounds, 25 times in an hour in their job. So, it can get a little silly where they get really paranoid and think that everybody's cheating when they're not.
Okay. This is from Jack in New Hope. Can workers' comp insurance company just stop the work comp checks whenever they want?
No, that's a big fear people have, and I understand that because you got to pay your bills, and it's a scary proposition when you're not real familiar with the system and what can happen. So we get that question a lot. Short answer is no. They can't unilaterally decide that they're annoyed and they're going to stop payment. Normally it comes with a court order, which means they establish that you have an earning power that meets or exceeds your pre-injury earning power, or that you're recovered, there's some other situations if you don't return LIBC forms within 30 days, or if you return to work somewhere, there's some situations where they can issue a notice of suspension of your benefits, your wage loss. But generally speaking, the answer is no. They can't just decide on their own to do that.
Well, here's a question. I'm surprised it hasn't come up yet, but this is from Sam in Philadelphia. He wants to know, how does a workers' comp attorney get compensated?
So it's a contingent fee system, meaning you don't pay us anything out of your pocket, no cash, no credit card. We only get paid if we win your case or settle it. So that's the beauty of our system. And a lot of people just refuse to believe it, but you don't have to show up with anything. If we win a petition that advances your case or get you benefits, or if you already own benefits and we prevent them from terminating them in court, fighting a petition to terminate, for example, then the judge will order the 20% to our firm, or if we settle the case. So a lot of people that are on workers' comp, they make a mistake. They don't lawyer up thinking everything's going great. You know, the adjuster's really nice and they seem to care for me. They're setting up the case for a termination. And the injured worker doesn't understand that they're already on comp. They can get representation for free and set the case up for a nice settlement down the road. So the contingent fee system is great. It allows, David to go up against Goliath and without having to fork over a check.
I hope people understand that when you go in to see Michael Cardamone for the first time, and he is going to set everything, and he's going to give you direction, and it's up to you because you're the client of what way you should go. But you don't have to write a check, and it's based on performance, basically. So
Correct.
You've got nothing to lose, and you go in with your own attorney, because let me tell you something, and you know this, Michael. Those attorney jobs with the insurance companies, their job is to pay you the least amount possible.
Absolutely. That's 100% their job. How can we limit our exposure? And I represented them for a year and a half earlier in my career, and I got to really understand the what's the word? And we need them. We need checks and balances. I'm not trying to discredit them. We need them in the system, but there's a lack of humanity. They talk about files and they talk about exposure and how do we get rid of this one? How do we get rid of that case? It's a language and a real detachment. And on our side, it's completely different. We see the face and we see their suffering. So there's a big discrepancy between the philosophy involved on each side of the fence.
I also think, Michael, with an attorney like yourself, you can see down the road a lot clearer than a person who's injured for the first time, especially someone who's never gone through the process before. Which helps you with the case, what down the road looks like.
Oh, we know exactly what's coming, and I'll tell them. And I get so many comments from the client saying, "Oh my God, you said you were going to get I was going to get an independent medical exam notice in a few months. And you were right. And then you told me what the doctor was going to say, that now I just have a sprain and I'm recovered." And I'm like, listen, I'm not bragging, but when you do something for 24 years, you get the drift of it, right? You understand, just like in their job, they understand how to do their job from top to bottom. And so the ability to look down the road and say, okay, here's what's going to happen, and to address it ahead of time and position your case properly, it's really important.
Michael, this has been the most enjoyable 30 minutes. We just had somebody who wrote, what can you do about a doctor who held up you getting surgery based on his opinion?
Really? Yeah, I mean, you're not going to really get anywhere, I don't think, in that situation. I mean, your doctors are entitled to have different opinions, so you're not going to have, in my opinion, a viable malpractice case, for example, if the surgery was delayed because of a difference of an opinion in a workers' comp case and the adjuster doesn't want to pay for it. they're waiting for a court order to determine if it's a work-related surgery. So that comes up sometimes, but there's really not much of a remedy there.
Michael, I got to tell you, it's such a pleasure to do your show because it's so obvious you really know your practice, your area of law. For the people who are listening on radio, give them your phone number.
Sure. 215-206-9068. And I really enjoy the show too, Steve. I could do this every day. Love it.
You're so good at it, and it goes by so fast. And it's 215-206-9068. It's a free consultation. Don't forget that. Michael Cardamone, he's with us the last Tuesday of every month. He'll be back in with us next month. And get those questions in, 954-336-3767. And we'll get Michael to answer your questions for you. Michael, have a wonderful week, and we'll see you soon.
See you soon, Steve. Bye-bye.
Bye. That's attorney Michael Cardamone. God, Michael's been with us for about 3 years now, and he just does workers' comp, and he is really good at what he does. It's not just the Philadelphia area. He handles the entire state of Pennsylvania. So we're lucky to have him, and thank everybody for tuning in. And we will be back with you next Tuesday at 10 a.m. with more Ask the Experts. See you soon. God bless.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.